Have you ever done, like, a seemingly simple favor for a family member?
Oh, yeah, we all have.
Right. You know the scenario. Bending a tiny administrative rule or maybe cutting a slight bureaucratic corner purely because you just want to help them out?
Yeah, it's so
You
common.
tell yourself that because you share a bloodline, the standard rules of the universe just, like, temporarily pause.
Yeah.
You think you're doing a solid, only to watch that one informal shortcut completely unravel into this cascading sequence of legal liabilities.
It is the classic trap of informal agreements. I mean, people tend to assume that family dynamics provide this shield against legal scrutiny.
Right.
But the legal system does not recognize your cousin's birthday or your aunt's financial struggles. It recognizes contracts, documentation, and codified liability.
Which brings us to our mission for today's deep dive. We're unpacking a classic Judge Judy case titled The High Cost of Family Favors.
Oh, this is a great one.
It's wild. We have a stack of notes detailing this transaction between two cousins over a used car. The seller allowed the buyer to drive away without properly transferring the paperwork or removing the license plates.
A huge mistake.
Massive. The goal today isn't just to recount the drama, but to really look at the underlying mechanics. Like, how does a seemingly minor omission at the DMV trigger this massive chain reaction involving tort law, vicarious liability, impound lots, and some incredibly bitter family litigation?
Well, the broader context here challenges how we typically view small claims court. There's a tendency to picture small claims as a venue for, elaborate scams or intentional fraud.
Sure, like bad contractors or something.
Exactly. But the most complex legal knots usually stem from entirely innocent intentions mixed with profound negligence.
Yeah.
It is the casual assumption that paperwork can wait that ends up requiring a judge to untangle.
Okay, let's unpack this. So the original transaction took place in March of 2014. The seller, Ms. Gore, agrees to sell her vehicle to her cousin for $3,000 in cash.
Simple enough.
The money changes hands without issue. But the buyer only possesses a learner's permit. She did not have a valid driver's license.
Which is a problem.
Right, so she can't legally register it. So Ms. Gore decides to just, leave her own license plates firmly attached to the vehicle and lets the cousin drive off, assuming they'll just sort out the registration later.
Which fundamentally shifts this from a standard sale into a legally precarious, ongoing relationship.
I mean, I look at leaving your plates on a car you just sold, like co-signing a 30-year mortgage for a house you don't live in, and handing the keys to a teenager.
That is a very accurate way to look at it.
You have zero control over whether they smash the windows or flood the basement. But when the bank comes to collect, your name is on the dotted line. You're adopting the financial risk of their behavior without, possessing any mechanism to regulate that behavior.
What's fascinating here is the intersection of DMV administrative code and civil tort law, because a license plate functions as a binding proxy.
Right.
It's an active, ongoing declaration to the state, and by extension to any injured party, that you maintain financial responsibility for that asset.
Wow.
Under the doctrine of vicarious liability, ownership of the plates often serves as a presumption of control. So, by leaving those plates on the car, Miss Gore voluntarily retained undivided civil liability for a 2-ton machine operating on public roads.
She completely neutralized the legal protection a formal bill of sale would normally provide.
Exactly. She gave up the physical asset, but kept all the legal baggage.
And she made no serious effort to retrieve those plates, even though she knew exactly where her cousin lived.
Because the law operates on the facts as they are documented, not the intentions behind them. From a legal standpoint, she was telling the state of New York that she was still the custodian of that vehicle.
And that documentation reality caught up to her a few months later. Ms. Gore starts receiving mail.
Never a good sign.
Never. First, she gets a handicapped parking ticket in the mail. Then she receives an official notice of an accident claim. Someone crashed the vehicle.
Oh.
And because her plates are still bolted to the bumper, the victim's insurance company is coming directly after her for the damages.
See, the administrative failure immediately ripened into civil exposure. Because the buyer only had a learner's permit, she could not legally register the car.
Right.
Because she couldn't register it, she couldn't obtain insurance. The vehicle was operating as a ghost in the system, tethered only to Miss Gore's identity.
Which forces us to clarify the actual lawsuit at the center of this deep dive. Miss Gore is terrified by these accident claims and the escalating tickets, so she sues her cousin to cover these costs and finalize the separation.
It makes sense from her perspective.
Yeah, But the cousin, who we'll see ends up with nothing, files a counterclaim demanding her original $3,000 back. They're both suing each other to be made whole.
It's a complete mess.
It really is.
Yeah.
But the twist in the courtroom comes when the judge asks who was actually driving the car when it crashed. Because it wasn't the cousin.
Right. It was the cousin's boyfriend.
Yeah, a man raises his hand from the gallery. He had been driving this unregistered, uninsured car every single day.
Just daily driving a ghost car.
And he admits to rear-ending a woman on an icy road. But according to the notes, Judge Judy actually praised him. She called him a prince.
Yes, she did.
I struggle to understand this. Like, wait, how does a judge look at a man who is recklessly driving an uninsured vehicle daily, causing a collision on public roads, and decide to praise him? That seems totally contradictory to everything the legal system stands for.
Well, it appears contradictory if you only look at the initial infraction, but courtroom psychology hinges heavily on how a party behaves after the damage is done.
Okay, go on.
In civil litigation, judges spend their days navigating evasion. Defendants dodge process servers, they obscure assets, invent wild excuses, point finger.
Keep doing anything to get out of it.
Exactly. The boyfriend certainly committed a tort by causing the crash, but his post-crash behavior was highly anomalous for small claims court.
He didn't try to blame the icy roads or deny he was behind the wheel.
He took absolute accountability. When Miss Gore accused him of ignoring the crash victim, he produced documentation proving he had already tracked the woman down.
Oh, well.
Yeah, he negotiated a $70 a month payment plan out of his own pocket and was currently current on his payments.
That is rare.
Very rare. And when questioned about the handicap parking ticket, he didn't fabricate a story about faded paint on the curb. He stated he never received the notice because it went to Miss Gore's address, and when asked if he would pay it, he agreed instantly.
He completely neutralized the conflict. He stripped away the need for fact-finding or cross-examination by simply conceding the points and adopting the financial burden.
Because judges can efficiently process accountability, they cannot efficiently process evasion.
That makes total sense.
His willingness to own the liability stood in stark contrast to the buyer and seller, who were locked in a bitter dispute trying to shift the blame for their informal paperwork disaster onto each other.
So the boyfriend, taking responsibility, handled the immediate tort claim for the crash. But it did absolutely nothing to solve the underlying bureaucratic ghost ship this car had become.
Not at all.
Miss Gore still had her plates on a car she couldn't control. So she finally calls the police to intervene and help her recover the plates. Police arrive, they realize the car is unregistered and uninsured, and they tow it.
Yep, off to the impound lot.
And it just sits there.
Creating a fascinating legal catch-22 for both parties.
See, that is the part I find mind-boggling. Why wouldn't Miss Gore just go down to the lot, pay the fee, and take the car back? Or the buyer, for that matter.
Right, you'd think someone would grab it.
But the car just sat there until the impound lot eventually auctioned it off to a stranger. The asset simply vanished from their lives.
You have to look at how impound lots operate under the law, specifically regarding mechanics' liens. An impound lot is a private business storing private property. They don't want to keep your car, they want to be paid for the storage space. But they cannot legally release a vehicle to just anyone who walks in with the keys.
Right. Anyone could steal a car that way.
Exactly. They require strict proof of legal standing, usually a formal title and valid registration in the claimant's name.
Which neither of them had in a coherent way.
Precisely the catch-22. Miss Gore had enough of a legal connection to the car via the plates to be held vicariously liable for the crash.
Oh.
But she did not possess the current title, proving she had the right to physically reclaim the property. The buyer, on the other hand, had physical possession of the keys, but no paperwork tying her identity to the VIN number.
So the impound lot is looking at two people who both lack the precise documentation required to release the vehicle. And the clock is ticking on storage fees at like $50 or $100 a day.
And once those fees accrue past a certain point, the lot exercises a mechanic's lien. This is a legal mechanism allowing a service provider to seize and liquidate property to cover an unpaid debt. The lot files the paperwork, announces the auction, and legally sells the car to recoup the storage costs. The original ownership claims are wiped out. The vehicle is gone.
Which drags us into the most bitter dispute of the trial, the missing paperwork. The cousin claims she never received the title to the car when she handed over the $3,000.
Of course.
Ms. Gore claims she only had an application for the title and that the original title was lost at her mother's house.
If we connect this to the bigger picture, a vehicle title is not a mere receipt of purchase. Under the Uniform Commercial Code and state laws, it is the physical embodiment of the chain of ownership.
Right.
When you bypass the formal transfer of a title, you break that chain. You cannot legally transfer an asset you cannot prove you own.
So what does this all mean for the trial? Because Miss Gore is standing in front of Judge Judy, claiming she lost the title at her mother's house, and the entire courtroom apparently erupted in laughter.
I mean, it's absurd.
The judge looked at the buyer and essentially said, "Your face is not believable."
It perfectly demonstrates the evidentiary standard in a courtroom. Testimony is evidence, but without corroborating documentation, it is incredibly weak evidence.
Yeah.
When Miss Gore admitted she didn't have the title, she essentially admitted to selling property she had no legal capacity to transfer at that moment. And the buyer simultaneously admitted to handing over $3,000 for an asset without demanding the legal instrument of ownership.
Both of them are demanding to be made whole, but neither of them can prove the foundational elements of the contract.
Exactly.
The car has been auctioned off by a third party. The plates were left on illegally. The driver wasn't licensed. The contract itself is entirely voided by their mutual negligence.
Right.
Like, how do you resolve a lawsuit where there's no physical evidence, no remaining asset, and both parties broke the rules?
A judge has to abandon strict contract law because a valid contract requires legality of purpose and capacity, which were severely compromised here, and pivot to the legal doctrine of equity.
I want to break down the calculus of this equity, because the timeline is crucial here. The cousin bought the car in March of 2014. She didn't actually obtain her official driver's license until April of 2015.
Which means she possessed the vehicle for over a year while legally barred from operating it.
Even though her boyfriend was clearly utilizing it daily,
Right.
Judge Judy starts running the math right there on the bench. The cousin lost her $3,000 investment when the car was impounded, but she, or her proxy, extracted a solid year's worth of utility from that vehicle before the police intervened.
It's like renting an apartment without a list. You still had a roof over your head.
Exactly. You can't demand a full refund a year later just because you never got the official paperwork.
Yeah.
So the judge asked the buyer what a rental car costs. The buyer admitted she was recently quoted $25 a day plus insurance.
And that is the basis for calculating quantum merit, or the actual value of services rendered. If you multiply $25 a day by 365 days,
The utility the buyer extracted from the vehicle easily exceeds $9,000.
exactly.
The final ruling comes down. Judge Judy dismisses Miss Gore's claim for damages, leaving her to deal with the DMV fallout herself.
Ouch.
But on the buyer's counterclaim, her demand to get her $3,000 back, the judge rules for the defendant, the buyer, for exactly $700.
Wow.
Not the full $3,000, just $700. The boyfriend keeps paying his crash debts. Nobody gets a completely clean slate.
It is a fascinating application of the unclean hands doctrine. When both parties walk into a courtroom having contributed to the mess through negligence, the judge balances the scales to prevent unjust enrichment.
Wait, I had to challenge this idea of fascinating equity. Is it really a masterful ruling?
Why wouldn't it be?
Look at the outcome. Miss Gore lost a $3,000 asset and still has a damaged driving record because of the tickets. The buyer, who drove without a license, let her uninsured boyfriend crash the car and never registered it, gets a $700 check for doing absolutely nothing right.
Well,
Doesn't splitting the difference like this just incentivize people to bypass the law? If they know a judge will just refund part of their money, even after they break all the rules, where is the deterrent?
I hear what you're saying, but you are looking for a punitive outcome in a civil court, which isn't the primary function of small claims.
It's not.
No, small claims is designed to restore balance, not necessarily to punish bad behavior. If the judge gave the buyer her entire $3,000 back, the buyer would have received a free vehicle for a year.
Which is unjust enrichment.
Exactly. But if the judge gave her nothing, Ms. Gore would have kept $3,000 despite failing her legal duty to provide a clean title.
Ah, I see.
Awarding $700 recognizes that Ms. Gore breached the implied warranty of providing the title, but it simultaneously taxes the buyer for the utility she consumed. It leaves both parties financially bruised, which is often the most equitable deterrent available in civil litigation.
So everyone pays a tax for their administrative shortcut.
Correct.
And you can really feel the weight of that tax in the aftermath. The notes describe a highly volatile scene outside the courtroom. I mean, no one is happy. The seller is still panicked about her license standing. The boyfriend is accusing the seller of lying about his behavior. And the buyer is livid that she only got a fraction of her money back and still lacks a vehicle.
The legal system applied a mathematical bandage to the financial dispute, but a courtroom is fundamentally unequipped to repair the shattered trust between relatives.
Yeah, there is a quote from one of the participants after the trial that really captures the collateral damage of this whole ordeal. She said, "I will never, ever do business with family again. Never."
An incredibly harsh boundary established after a very expensive lesson in liability.
It is the ultimate takeaway for you listening right now. We all encounter those situations where a relative asks for a favor and they use those dangerous words. Don't worry, we'll figure out the paperwork later.
Or it's only temporary.
Yes. What begins as a momentary lapse in judgment to avoid a Tuesday morning at the DMV can snowball into a legal quagmire. You could lose your property to an impound lot, face civil liability for a crash you weren't involved in, and permanently destroy your family relationships over a missing piece of paper.
It really presents a compelling structural question about how we organize our lives. The legal system demands strict black and white documentation to function safely, registered plates, physical titles, and clear demarcations of liability.
Right.
Yet, family dynamics inherently rely on the exact opposite. They rely on